Our next case this morning is People versus Mark Robertson. This is case number 25-3635 F8. Is that, oh, wait, Mr. Robertson, come on in. Do we have counselors?
Please, sir.
I think it's...
Yeah, Ms. Ottawa. Oh, we have Ms. Lynn Getz. She works with Ms. Ottawa's office. I know, hold on. Let me get, first of all, appearances. Go ahead, Mr. DenHoughten.
Thank you. David DenHoughten on behalf of the people.
Lynn Getz on behalf of Mr. Robertson.
All right, thank you. Now, Mr. Robertson is here in the courtroom with us. Also here before us is Mr. Luke Blazak, an agent from the Michigan Department of Corrections, who prepared today's pre-sentence investigation report. Mr. DenHoughten, do we anticipate hearing from any victim in this case?
No, Your Honor.
Okay.
Your Honor,
Yeah.
if I may, on behalf of my client, I'd respectfully ask for a brief adjournment, even if just 1 week. Unfortunately, we had an intern here who scheduled this as a final pretrial. She did not put sentencing, and I did not therefore get access to the PSI. I'd like time to go over it with my client. In addition, he has some support letters that we believe would help the court understand who he is and tailor a sentence to fit him more appropriately, knowing what kind of man he is. So I'd ask for just a 1 week adjournment if I could.
All right. One moment. I do note that I don't know if Ms. Ottawa sent me a request to adjourn today in this file. I know her office, for whom Ms. Getz works, had it sent requests in a couple other files. I know that Ms. Ottawa, who's very involved in the CDAM organization, Criminal Defense Attorneys of Michigan, they had a conference, I think, earlier this week. And so I understand that may have been an issue. I had rejected a lot of stipulation requests, and I say a lot, a couple this week, but those were mostly for final pre-trials, as I recall. So, okay. Let me turn to Mr. DenHoughten. By the way, the law says I have to allow the opportunity for the defendant to talk with counsel to go over the PSI. So I'm there's really not a whole lot we can say.
I understand, Your Honor. I'm the first one out of professional career state. Yeah. If a request is made, I typically sign it.
I know.
It's just somewhat unfortunate, and I guess I would speak on behalf of the many people that came here for sentencing. Sure. Had we known, even as late as yesterday, we could have advised the appropriate party. So that's a concern. Having said that, I'll leave it to discretion of the court.
It is a concern. There are probably a couple of different ways I could go about it, which we'll talk about in just a moment. Ms. Getz, I'm not making a decision. And again, by the way, Ms. Getz appears today via Zoom. And that's the reason, I'm sorry, one of the couple of ways. Number one, I could have listened to a statement made by a victim, but as we already asked, there's no victim impact statements to be made here in the court today. Is that still true?
So there are individuals that have expressed an interest in terms of making a statement. I didn't know if the court were inclined to allow those statements because it wasn't directly pertaining to this particular incident. That was the concern that I had by the people. So that's why I indicated that with respect to this particular incident.
So let's break this apart. We have a victim for the particular incident for which there was a conviction, correct?
We do not, Your Honor. This is a decoy situation. So there is not.
Okay, got it.
Right. Yes, Your Honor.
But there are victims from past situations?
There are individuals who have indicated that they have been a victim of the defendant.
Okay.
Yes, sure.
So, and those did not result in any charge?
They did not, Your Honor.
Okay. So the next question is, was there ever a notice given, say a 768 notice that they may testify, say if there was ever a trial?
There was not, Your Honor.
Okay. So, all right. This raises a particular interesting question. And by the way, for those that are here visiting, when I say interesting, because whenever you say interesting in other situations, people think, ooh, that means something silly. No. It raises a question that is interesting because I haven't dealt with it before. So, a court can consider at sentencing factors for placing sentencing, which there is a demonstration of a preponderance of the evidence that I can make a finding. I'm sorry, that I could consider it. Now, whether or not I can or can't consider it if it wasn't a factor considered in the case is another question. So for instance, that's why I asked the 768 notice question, because if there had been a 768 notice question, then I think I could have considered it. Now I'm not really certain if I can, but I don't want to shut that down if that's an option, right? I don't want to shut down a person. And I believe 768.27A or that might be C. It says it can't be used for any other purpose. 1 second. Ms. Getz, just make sure you're making notes. I'm going to give you your adjournment, but I just want you and or Ms. Satawa, when you're enjoying your adjournment away from our court here, you guys are using your time effectively. And I also want to ensure that any victim or alleged victim has the right to make a statement. So give me just a moment to consider something. So the statute is MCL 768.27A. Okay, the language that I was looking for, that I thought I recalled in my head, does appear in the statute. And so Ms. Getz, who I know is paying dutiful attention, as is Mr. DenHoughten. The citation again was MCL 768.27 small a, parenthetical 1. It does say that the evidence involved, I'm paraphrasing, evidence of an offense against a minor, this is where I'll quote, is admissible and may be considered for its bearing on any matter to which is relevant. That phrase, which is relevant, is the point. Is it because it doesn't say just at a trial, right? So, because I would want any other, and plus, by the way, Ms. Getz, I know when you go talk to Ms. Satawa, yes, I know there's the other statute that regards victim impact statements at sentencing, which I think is MCL 771. No, that's 770 maybe. Well, I'm not going to sit here and do everybody else's research. So anyways, I'm going to have to look at it too, but there's another one that talks about when a victim who is declared as a victim. All right. But because it says as relevant, that is relevant, I think it's a good question. So I'm going to grant the adjournment. My office will reschedule the sentencing. Hopefully it's within the next week, but that will be dependent upon my office and my availability as well as counsel. And this would allow Mr. DenHoughten, on behalf of the alleged other victim. By the way, when I say the word alleged, please don't be offended. It's just that I don't know anything about it. And it'll allow Ms. Getz or Ms. Satawa or Ms. Castle or anybody from that office who decides wants to appear that day, not only the opportunity to go over the PSI, but also to be able to address this question effectively, because of course I don't want to disrespect either rights of either parties. All right. Anything further that you need to put on the record today, Ms. Getz?
No,
besides the defendant's bond hereby continues. Anything else, Mr. DenHoughten?
Not for today.
All right. So that's sort of again for Mr. Robertson and for any other alleged victim in this case. I think that my ruling today here is fair and appropriate. It may be somewhat uncomfortable to have to postpone closure for either sides, but out of an abundance of caution, respect to due process and the statutes, I find that it's the right thing to do today. Therefore, we will adjourn and reschedule. Thank you. Your bond hereby continues. We are adjourned.
Thank you,
Thank you, Your Honor.
Thank you. I'm going to Linda keep that PSI bill, of course. I've got it with me. Thank you. All right.